Hi, this is Andrea Kane, and I'm here with you for HIT 210. We are still on week 4, but now we've moved on to chapter 9 about workers' compensation. The objectives for this chapter are on page 155 in your textbook, and they're essentially for us to look at the key terms that relate to workers' compensation, talk briefly about the history of workers' compensation, including statutes and reform, state the purposes of workers' compensation laws, discuss workers' compensation program funding and the way that premiums may be purchased by an employer, define and discuss second injury fund, look at who is eligible for insurance coverage under federal workers' compensation laws, name persons entitled to be insured under state workers' compensation laws, determine the waiting period in each state before benefits begin. We aren't actually going to look at each state, but we'll talk about the fact that there is a waiting period. Describe the types of compensation benefits. We really want to focus on the terms non-disability, temporary disability, and permanent disability as it relates to workers' comp claims. Talk about signs of fraud and abuse. Talk about when to report fraud or abuse that involves a workers' compensation claim. Talk about some depositions and what is happening when a lien is filed. Also bring in third-party subrogation. Then then describe workers' compensation health and financial record keeping in the medical practice and talk through the procedure of completing the doctor's first report. And then we'll name the contents of a progress of supplemental medical report. The last couple of things include completing workers' compensation forms properly and discussing fee schedules, talking through electronic claim submission and how to handle out-of-state claims, and then actions to take in following up on delinquent workers' compensation claims. Now again, you probably won't run across a whole lot of this as an MA unless you're directly dealing with the billing end of things. So we're going to skim through this like we did with TRICARE and like we will do with disability in the next chapter. So looking at history, if you turn to page 156 in your book, it talks about how the first workers' compensation laws were enacted in 1911. Today, all states have workers' compensation laws. And notice that the states each have their own. There are some federal workers' compensation laws, but most that involve most individuals are state-based, and so they vary state to state. Workers' compensation is the most important coverage written to insure industrial accidents because workers' compensation is all about happening on the job or happening while you're working or being related to the job. The first thing we need to know is that federal compensation laws apply to miners, maritime workers, and government workers. That's who the federal laws apply to. State laws apply to employers and employees within each state. So for most of us, we're never going to be covered under the federal laws. It'll always be a state law that we go to for our coverage. There have been reforms over time because of systemic abuse and fraud. As I mentioned, laws vary from state to state. Some of the issues you may run across are making sure that the person has proof of medical necessity, that their treatment is pre-authorized, that there's a review of the bill, you'll notice that there are caps on vocational rehab, and a lot of times they'll use mediators to deal with workers' compensation issues rather than taking those to court. The purposes of workers' compensation laws are to provide the best available medical care to the injured, to ensure maximum recovery, to provide income to the injured regardless of fault, to reduce overall expenses, resolution time, and litigation, to encourage employer workplace safety, and to promote study of workplace accidents and hazards and facilitate improvements. And you'll find this information in your book on pages 156 into page 157. Most companies choose to be self-insured, those that are large enough to be. A lot of healthcare providers are. And the company pays for medical expenses instead of insurance premiums. But the employee is still covered under the Employee Retirement Income Security Act, or ERISA. There are stop loss provisions that may be included in these self-insurance policies. The program may involve reinsurance on large claims, and oftentimes you'll see captive insurance plans serving smaller companies and outside firms administering claims processing. A lot of these programs are managed care. They use managed care contracts to handle these. As we know from studying a couple of weeks ago, managed care contracts are not uniform, then they can limit the choice of providers. And there are all sorts of different flavors. So it really depends on what the organization or the employer decides to provide. Private business, state, and federal employees are entitled to workers' compensation coverage. A workplace accident that results in injury is covered. Illness or disease that results from environmental factors in the workplace is also covered. Another example of workers' comp could be that if you are a home health nurse or aide and you go into someone's home, or you're driving to someone's home and an accident occurs, you're covered under workers' compensation because you're technically working for your organization at that time, even though you're driving or even though you're in someone else's home. You're counting your work duties, and so that's why you're covered. Of course, we talked about federal laws, and that governs government employees such as postal workers, FBI agents, workers in Washington, D.C., coal miners, maritime workers. Those are all part of the federal laws. Then you get into the state laws, and they essentially cover everyone who's not part of the federal laws. Employers have to purchase workers' compensation insurance from a private company or be self-insured with adequate cash reserves. An employer must also have employer's liability insurance. So not only do they have to carry workers' comp, but also employer's liability. State laws do provide coverage for minors. Most are effective outside the state and provide coverage for civil defense and other volunteer workers. Employer and physician requirements for filing injury reports vary by state. So again, the laws vary by state and the requirements vary by state. But every state is required to have a workers' compensation law for their state. In your book, on page 157, it talks about the second injury fund. This is where someone gets a subsequent injury, and that pre-existing injury combined with a second injury produces a disability that's greater than that would be caused by the second injury. Okay, so if you have a previous injury or condition and then you're injured on the job on top of it, and your disability is now greater than it would have been if you just would have had the second injury without any previous injury or condition, that is the definition of a second injury fund eligibility. And the reason for this is to encourage the hiring of physically handicapped individuals, and it allocates benefit costs more equitably. So state laws usually set a minimum number of employees that can vary by state, and some occupations are exempted. So it's interesting to look up, according to your state laws, who's included and who's excluded from the state's, your present state's workers' compensation laws. And there are waiting periods, and they do vary again by state, but there is a required time period that has to elapse before income benefits are payable. Sometimes that can be 6 months. Sometimes it can be a year. Sometimes it can be 3 months. It's just interesting to look up that information if that's a situation that you might be dealing with. Benefits, they are to cover medical treatment, temporary disability indemnity, permanent disability indemnity, death benefits for survivors, and rehabilitation benefits. That's all to be part of it. Types of state claims. This is really important. This is probably one of the most important slides here that you really need to know. Non-disability. The definition of that is a minor injury that requires medical attention, but the employee is still able to work. That's non-disability. Temporary disability is the employee is unable to perform their work duties for a specific period of time, but after that period of time, they can go back to performing their work duties without any constraints. They can do all of their former work duties after that temporary time away. A permanent disability is when someone is unable to return to their previous occupation because their disability prohibits them from doing it, meaning that they can never go back to doing that. Whatever their job was, they are incapable of doing it. For instance, it might be that someone had a job that was heavy in typing and they have some type of hand injury, or end up having to have their hand amputated. That's a permanent disability. They can't go back to that same career and perform that job duty. Whereas a temporary disability might be in that same individual to have carpal tunnel, and they have to be off to have carpal tunnel surgery and afterwards a couple of weeks off to let it heal, let the swelling go down, maybe have a little bit of physical therapy, but then they're able to go back to work, perform the same job duties. That would be a temporary disability. Unfortunately, as with anything in life, there are people who take advantage and commit fraud or abuse. And physicians are responsible for determining the legitimacy of work injuries and accurately reporting the findings. Unfortunately, some physicians are dishonest and others are very honest. You have some that are very careful to make sure that they're accurate in what they report, and you have others that are a lot more creative, shall we say, in their reporting. And then unfortunately, there are some who have signed off on people who really no longer have a disability, but they continue, excuse me, I'm going to sneeze. Excuse me, continue to report as if they do. Excuse me, goodness. Sorry about all my sneezing. I've taken some allergy medicine, so hopefully that'll kick in and help me a little bit more here, and I won't sneeze so much. All right, getting back to fraud and abuse. So all individuals who deal with workers' compensation cases must report suspicious situations to the insurance carrier. And that just goes back to ethics and integrity and making sure that we're all honest about what we see and do. Actions can be taken to have the case investigated further by personnel from the fraud divisions or referred to the district attorney's office. OSHA, have you ever heard of OSHA? They are a government agency that was created to protect employees against workplace health and safety hazards. And they come in and they will investigate. Usually they come in on an unannounced survey, and they can come in at any time. They can come in from receiving an anonymous complaint. They can come in like every 10 years and just survey for the fun of it, for just to make sure that organizations are maintaining a safe work environment. And non-compliance to the standards, to OSHA standards, can result in fines, some significant fines. Businesses are responsible for making sure that their workplaces are safe. And that's what OSHA is all about. And so you may hear of OSHA coming in and doing an investigation, or OSHA coming in and doing a survey. I've seen that happen a couple times in my career. And it's actually helpful to be able to talk to them, and they'll share with you some of their experiences and some of their knowledge. Even if you don't have a problem, excuse me, it's really helpful to see through their eyes what they're looking for and how they've seen good examples and bad examples. So if OSHA ever comes in, it's not a bad thing. It's actually helpful because truly they are motivated to keep it safe for employees. So there are legal situations that come into play when it comes to workers' comp. Typically, there is a medical evaluator. This is a physician who conducts medical legal evaluations of injured workers. They have to pass a special medical exam and become certified. They are usually hired by an insurance company or appointed by an appeals board, and their purpose is to conduct unbiased assessments of employee disability to see again, is it non-disability, temporary disability, or permanent disability. And again, disability is separate from workers' comp in the sense that the first thing that happens is that workers' comp is responsible if it happens in the course of someone's work. And after their workers' comp reaches a certain point where they've determined the level of their disability, for instance, if it's total disability, that's when disability through Social Security benefits comes in, excuse me, and picks that up. So you can have workers' compensation, and that can then transition into disability. Or you can not have workers' compensation and just be dealing with a disability situation. For instance, if someone becomes disabled through an accident outside of work. Anyway, going back to the legal situation, part of all of that with workers' comp can involve depositions, medical testimony, all those types of things. And then there's such a thing as a lien. And a lien is a legal claim on the property of another for the payment of a debt. And most often liens happen, at least how I've been involved with liens, is from a hospital standpoint, that maybe you have a patient who comes in and they are treated for their workers' compensation injury. The hospital will not bill anyone until it's clear who's going to be responsible for the bill. They put a lien on that situation, on that account, and as it is adjudicated and figured out who's going to pay what, then the hospital goes after them, and that whoever's responsible will pay, whether that's workers' compensation insurance, whether that is an employer's insurance, all these different things. Another way I've seen a lien used is, as they talk about on this slide, with third-party subrogation. An example might be that I used this example before, that you're traveling in your car, it is work related, you're heading to a patient's home to provide care, you're in an auto accident. They often will go ahead and put a lien on that to figure out who's going to pay. Is it going to be your auto insurance? Is it going to be your employer's auto insurance? Is it going to be the other driver's auto insurance? Is it going to be workers' comp? So there's all this stuff that comes into play, and they have to figure out who's going to pay first and how much they're going to pay, and that's where it gets into a lot of the legal stuff. So going back to liens, advantages are that the court recognizes written agreement, provides protection in event of litigation, ensures payment for medical services, provides an inexpensive means to collect full fees. The judge determines if the fees are reasonable when the amount billed is more than the amount allowed, and it helps avoid problems with collections. But again, unless you're heavily into claims and billing, wherever you end up, you probably won't be involved in any of this. Health information record keeping. It's interesting to see how they list this out for you. You don't necessarily need to maintain a separate medical record. In fact, I'd encourage you not to do that. But you do need to be able to pull out the records or the pieces and the parts that have to do with workers' comp when it's requested. And again, I guess if it's paper record, that would be easier to do, and same thing with financial ledger. but it should be clear in your financial software and in your EHR that this is a workers' comp visit and that the information that has to go with it is all workers' comp. Um, Again, when a patient comes in for an appointment, their appointment should either be for themselves outside of that occupational injury, or it should just be for the occupational injury. You don't want to have an appointment where you're not only doing the occupational injury assessment and whatnot, as well as their personal outside of that occupational injury, because it gets the record murky. So you want to, if they're coming in and they've got more than one issue, like they've got their occupational injury and then they have something else, you might want to have separate appointments so that they come to the first appointment, they do their occupational injury, then technically it becomes a second appointment, even if they're still in the room and it's during that time, and their second appointment then becomes about their unrelated issue or concern. And then, of course, you want to keep your documentation um, clearly separate. And a part of this is because of discoverability, that the patient loses some of their confidentiality when it comes to occupational injury because it's workers' comp, and so the employer has access. So if there's something that's super confidential or something the patient doesn't want their employer to see or know, that's why you want to keep it separate. Terminology, you already probably know all the terminology you're going to need. There's not a whole lot more that you're going to need. Reporting requirements, there is an employer's report that has to be filed within a specified time limit explaining what happened, how the injury was caused, and all of that. There is usually a medical service order that authorizes a physician to treat the injured employee. And then there's the physician's first report. And that's where they examine the patient for the first time and they say, okay, here's the situation. And they need to make sure in this first report that they indicate what level of disability they believe the patient has at the present time. And then there are progress or supplemental reports that come as the patient is seen subsequently. And again, these are important to track what's going on with the patient's disability. Has it transitioned from partial to a permanent, or partial to total? Those are important things to know. When it comes to financial responsibility, workers' comp is billed for the expenses. So that's why they don't go after the patient for any of the cost, or they should never go after the patient for any of the cost of their medical care related to the injury. That all needs to go through workers' compensation. And the physician that's treating the patient agrees to accept payment according to the carrier's fee schedule. And then you would just go through the same process as you always would. It's just that you file the claim to workers' comp. Again, fee schedules usually follow whatever workers' comp pays, or a Medicare fee schedule, something like that. Oftentimes there's a maximum reimbursement amount, and the employer, state agency, insurance carrier, or payer may audit or review the fees. Most everybody does electronic claim submission now, as well as electronic reporting. It is possible to do out-of-state claims. You just follow the regulations for the state in which the injured worker was hired. So let's say that someone goes on a business trip. Let's say you work for a hospital here in Iowa and they send you for training in Chicago and the injury occurs in Chicago. That would be an out-of-state claim because you're employed by the hospital in Iowa, and that's who has to do the claim submission. It's not where the injury takes place so much as it is where you are employed. And then, of course, the hospital in Chicago that would treat someone under those circumstances would have to obtain and follow all the out-of-state fee schedule for Iowa for billing purposes. And then this is just some bullet points on what to do if you have delinquent or slow pay claims. And again, if you're doing billing, this makes perfect sense and you would want to do that. And then, oh, I just noticed on page 160, there's a waiting period for income and medical benefits in terms of days. And then there's a box 9.1 on page 167 of signs of workers' comp fraud and abuse. It gives you some examples of some forms to look at on pages 168, 169, 170, 171, 172. And then gives you another example of a form on page 175. It gives you a sample table of employers or physicians' report of accident, of when they need to submit their report of the accident and what kind of injuries that covers. That's pages 176, 177. And it gives you an example of a CMS 1500 form on page 180. Some more report examples on page 182, page 183, and even 185. 186 and 187 have some additional information, examples of forms and whatnot. Page 188 has your key points. I would just make sure you run through those. And that is it. So I will be back shortly to talk about chapter 10, which is disability. Different than workers' comp, but sometimes they go hand in glove.